federal judge has blocked the administration from ending temporary protected status for nearly 1 million migrants from Haiti and Venezuela.
The Supreme Court says the Trump administration can cancel temporary protections.
There's a legal document that was published today that immediately changed the legal status of over 600,000 people living in the United States, and the implications extend far beyond just those individuals directly affected. The Supreme Court issued a 6-3 ruling that fundamentally shifts how temporary immigration protections work, who has authority to terminate them, and whether federal judges can intervene when administrations decide to end programs that have the word temporary in their official name but have lasted for over a decade in practice. This wasn't just another routine legal decision. It represents a decisive statement about the balance of power between the executive branch, the judicial system, and the bureaucratic mechanisms that have transformed short-term humanitarian responses into quasi-permanent immigration pathways. The ruling addresses temporary protected status, a program created in 1990 as a short-term humanitarian response to natural disasters and armed conflicts in other nations. It was designed to last 6 to 18 months maximum, providing safe haven until conditions improved enough for people to return home. But bureaucratic extensions turned months into years, and years stretched into decades. Some individuals have maintained this temporary status for over 12 years continuously. The Supreme Court examined this situation and concluded that the executive branch possesses authority to end these protections without requiring permission from lower court judges who had been blocking such actions through injunctions. What follows is an examination of what this ruling actually says, which judge became the focal point of controversy by repeatedly blocking enforcement actions, why 3 justices dissented so strongly, and why this decision's impact will extend far beyond the specific individuals who currently hold temporary protected status. The numbers behind the ruling. The immediate impact affects approximately 600,000 individuals currently holding temporary protected status, but that figure only tells part of the story. Venezuela accounts for roughly 350,000 of those individuals, while Haiti represents another 250,000. But TPS designations have been granted to populations from numerous countries including El Salvador, Honduras, Nicaragua, Nepal, Sudan, South Sudan, Syria, Ukraine, and Yemen over the past 15 years. When tallying every country that received TPS designations during this period, the total number potentially affected approaches 1.2 million people. Not all will lose protection immediately because some country designations haven't been challenged and remain valid under current policy. But this Supreme Court ruling establishes legal precedent that any temporary status can be terminated without courts interfering based on procedural objections. The average person holding TPS has resided in the United States for over 12 years, more than a decade under a status explicitly labeled as temporary. During that time, these individuals have been working legally, contributing to Social Security, holding jobs, signing residential leases, enrolling children in schools, and building lives with the reasonable expectation that their status would continue being extended indefinitely as it had been for years. The economic disruption argument formed a significant part of the dissenting justices' reasoning, suddenly removing work authorization from hundreds of thousands of people who have been legally employed would cause substantial disruption to businesses, communities, and families. But the counter-argument presented by the majority holds that maintaining people indefinitely under temporary status creates different but equally significant problems, particularly by incentivizing additional unauthorized immigration based on expectations that temporary protections will become functionally permanent. The judge who became the roadblock. Judge Edward Chen sits on the federal bench in the Northern District of California and has been the primary judicial obstacle to terminating these protections. Before being appointed to the federal judiciary in 2011, Chen spent years working as a staff attorney and national board member of the American Civil Liberties Union, the same organization that has been litigating extensively against immigration enforcement actions. Chen has ruled against immigration enforcement policies in over 40 separate cases since assuming his position on the bench. His San Francisco courtroom has effectively become a preferred venue for immigration advocacy organizations because they can reliably predict how he'll rule on enforcement questions. In this particular case, Chen issued an injunction blocking the government from ending TPS designations for Venezuelan and Haitian populations, arguing the administration failed to follow proper procedures. He extended the protected status multiple times through repeated injunction renewals, pushing deadlines from month to month in what legal observers describe as injunction creep. where temporary judicial orders gradually transform into quasi-permanent restrictions. The Ninth Circuit Court of Appeals consistently upheld his decisions, which is precisely why this case required Supreme Court resolution. This pattern reveals a broader phenomenon that has developed over the past decade: forum shopping. Advocacy organizations strategically file lawsuits in judicial districts where they expect sympathetic rulings. They obtain nationwide injunctions that apply across all 50 states, not just within that particular district. Appeals then take years to progress through the system, during which the injunction remains in effect. By the time cases reach the Supreme Court for final review, the temporary status has been extended so many times that advocates argue terminating it would cause unacceptable disruption. The dissent that reads like advocacy. Justices Ketanji Brown Jackson, Sonia Sotomayor, and Elena Kagan formed the dissenting bloc, with Jackson authoring the primary dissenting opinion. Her 14-page analysis spends substantial portions describing humanitarian conditions in Venezuela, economic collapse, political repression, lack of basic services, arguing that returning people to such difficult circumstances is inherently problematic regardless of what immigration statutes technically permit. The logical challenge with this reasoning, as the majority opinion notes, is that it would effectively make temporary protections permanent for populations from any country experiencing instability. The State Department currently maintains travel warnings for 54 countries due to concerns about local conditions including violence, instability, or inadequate infrastructure. If the standard becomes, we cannot return anyone to a country with significant problems, then temporary humanitarian protections transform into permanent immigration pathways for populations from dozens of nations. Jackson's dissent also argued the administration failed to provide adequate reasoning for terminating the protections. But the majority opinion countered that the law doesn't require the government to explain in detail why a program explicitly labeled as temporary is ending. The temporary nature itself provides the rationale. Requiring elaborate justifications for ending temporary programs effectively converts them into permanent ones that can only be terminated through extensive administrative processes. The philosophical divide between the majority and dissenting justices reflects fundamentally different views about the role of courts in immigration policy. The dissent adopts a position that courts should scrutinize executive branch decisions about humanitarian protections and can block those decisions when judges conclude the reasoning is insufficient or the humanitarian impact too severe. The majority holds that immigration enforcement authority belongs to the executive branch, and courts shouldn't substitute their judgment about policy wisdom for executive determinations. The shadow immigration system courts created. Over the past 8 years, federal district judges have issued more than 300 nationwide injunctions blocking various immigration enforcement policies. This represents a dramatic expansion of judicial involvement in immigration matters that historically were considered primarily executive branch responsibilities. A single judge in one district can halt enforcement across the entire country through one legal order. The Supreme Court's ruling sends a clear signal to lower courts that they cannot continue substituting their policy preferences for executive branch authority on immigration matters. The Constitution grants Congress power to establish immigration law and assigns the executive branch responsibility for enforcing those laws. District court judges aren't authorized to override enforcement decisions simply because they disagree with the policy choices being made. This dynamic has created what legal scholars describe as a shadow immigration system, where actual policy gets determined not by statutes passed by Congress or enforcement priorities set by administrations, but by which federal judge happens to hear a particular case and whether that judge issues an injunction blocking enforcement. The geographic lottery of where cases get filed has become more important than the underlying legal merits. The precedent that extends beyond this case. The Supreme Court didn't merely rule that the current administration can terminate TPS for specific countries. They established precedent that any administration possesses authority to end any temporary immigration program without requiring elaborate justification to satisfy federal judges. This represents a substantial shift in the balance of power that has been developing over decades. For years, immigration policy has resulted from interactions between congressional statutes, executive actions, and judicial interpretations. Courts have been willing to intervene extensively, blocking executive actions by finding violations of the Administrative Procedure Act or determining that agencies failed to provide adequate justification for policy changes. This ruling establishes that when temporary immigration statuses are involved, the executive branch possesses nearly unreviewable discretion, If future administrations want to terminate DACA, this precedent supports such action. If officials decide to end temporary protected status designations for multiple countries simultaneously, this ruling indicates courts cannot block those decisions based on procedural objections about inadequate explanation or failure to consider alternatives. The majority opinion specifically rejected the concept that governments must provide detailed explanations or evaluate alternatives before ending programs explicitly designated as temporary. This will likely embolden current and future administrations to take actions they might have hesitated on previously, knowing that courts are now less likely to issue injunctions blocking implementation. The legal landscape for challenging immigration enforcement decisions just shifted dramatically toward executive authority and away from judicial oversight. The broader immigration debate this reveals. What makes this case particularly significant is how it exposes fundamental disagreements about immigration policy that extend far beyond the specific legal questions about temporary protected status. One perspective holds that humanitarian considerations should override strict adherence to the temporary nature of protection programs, that courts should scrutinize executive decisions carefully, and that disrupting established lives, even when those lives were built on explicitly temporary legal status, creates unacceptable hardship. The opposing perspective argues that failing to enforce the temporary nature of temporary programs creates incentives for unauthorized immigration, that judicial interference with executive enforcement authority undermines the constitutional structure, and that allowing temporary statuses to become functionally permanent through endless extensions makes a mockery of the law. Neither position is entirely unreasonable. There are genuine humanitarian concerns about returning people to dangerous or unstable conditions after they've been in the United States for over a decade. There are equally valid concerns about rule of law, incentive structures, and whether temporary humanitarian responses should transform into permanent immigration pathways through administrative inertia rather than explicit congressional authorization. So here's what actually happened today. The Supreme Court issued a 6-3 ruling that the executive branch has authority to terminate temporary protected status designations without elaborate justification and without lower courts blocking those decisions through injunctions. This immediately affects approximately 600,000 individuals currently holding TPS, with potential implications for over 1 million people if the precedent gets applied to all temporary immigration programs. 3 justices dissented strongly, arguing that humanitarian conditions and the disruption caused by removing protections should be factors that courts can consider when reviewing these decisions. But the majority held that temporary programs can be ended because they are temporary, and that courts shouldn't substitute their policy preferences for executive branch enforcement decisions. The ruling also establishes precedent extending beyond this specific case, indicating that future administrations have broad authority to terminate various temporary immigration programs without extensive judicial oversight. This shifts the balance of power decisively toward executive enforcement authority and away from the pattern of lower court judges issuing nationwide injunctions blocking immigration policies. Whether this represents proper restoration of constitutional authority or dangerous reduction of judicial checks on executive power depends largely on one's broader views about immigration policy and the appropriate role of courts in reviewing enforcement decisions. What's undeniable is that the legal landscape for immigration enforcement just changed substantially, and the effects will unfold over coming months as administrations test the boundaries of this newly clarified authority.